Today I'm going to be talking about a O-1 mandamus case that was just approved. And the reason why it's so special is because the client was from one of the countries listed on the travel ban. And as you guys know, there was a nationwide benefits pause. And so for our client, she was just extended her O-1. It was supposed to be a routine filing, but since USCIS issued this benefits pause, her case has been on hold since January 2026. Her only way to get this approved was to file a mandamus. Backstory on our client. She's been here for 20 years in the US. She has her bachelor's, master's, PhD. She got hired by a leading global biopharmaceutical company, and she's been working as a PhD researcher on an O-1 visa. And she did so without ever violating her status. She doesn't have a criminal record. She's what we would call an ideal candidate, someone we would expect a routine O-1 filing to go very smoothly. And so she filed her O-1A extension back in fall 2025 because her status expires in February. They didn't expect anything of it. It's something they've always done. And lo and behold, there was a national policy that was issued January 2026. So in response to the USCIS benefits hold, the law firm that prepared this case filed her case with premium processing. And within 15 days, she got an RFE stating that she was subject to the country-specific policy, saying that because she was a national of Myanmar, it was considered a significant negative factor. And so now she had to prove documents and evidence to overcome this negative factor, showing that she's likely to be a public charge. Now, mind you, she makes 6 figures. She's been working in a professional job, working for one of the top, 10 companies in her industry. And so she had a lot of documents to show her ties to the US, showing the nature of her work and why it's of national interest, that it should be subject to the exception of this policy, showing that she has a lot of financial support and means, so that she's very highly unlikely not to be a public charge. Her and her attorneys prepared this packet, submitted it to USCIS. After the 50 business days period had passed, she still hadn't heard back on her case. And when she inquired on what was going on, she was just told that the case was on administrative hold without any further information. And I know there's a lot of people out there like her that filed their cases with premium processing only to have their cases on hold. They never got a refund. It was just kind of in limbo. And that's when she found us. And we helped prepare a mandamus case. And at the time, there were some individual cases that were being successful. We thought she was a good candidate for the mandamus because her case had been pending for at least 6 months. And the nature of her work, we could show that it's of national interest. She has no immigration violations. She doesn't fall into any of the categories that are of high risk. So we prepared her case very quickly. And it just happened to be that right before we filed the complaint with the district court, there was another ruling that was issued, and that was the Dorcas ruling in Rhode Island. And there, the district judge vacated 4 USCIS policies, including the benefits adjudication hold policy, the country-specific factors policy, the global asylum hold policy, and also the comprehensive review. So we call those arbitrary and capricious, and those have been struck down as of June 5th, 2026. So we were really lucky. We filed the complaint about a week later, and in 2 weeks, her O-1 case was approved.